Today is the first hearing at the Supreme Court of the appeal brought by Peter Obi of the Labour Party, Atiku Abubakar of the PDP, and of course, Allied People's Movement. More on the reprimand they got from the court in a moment. After rumors about the Supreme Court justices that will hear this appeal, Justice Inyang Okoro is the chairman of the panel. You can see the other members on the screen. There was serious security in the court today. Only a handful of media teams were allowed entry into the Supreme Court premises. Many lawyers were also denied entry. Only a few lawyers that are representing different parties were allowed entry. Now to the legal arguments. The Supreme Court heard Atiku's motion to admit new evidence that he got from Chicago State University. Atiku's lead counsel, Chris Uche SAN, pleaded with the court to allow him to present fresh evidence, especially the oral deposition that was made by Chicago State University's representative. He told the court that they made the application for the admittance of new evidence on 20 grounds, and they received a counter affidavit from the respondents, that's INEC, Tinubu, and APC. He reminded the court that Tinubu's certificate forgery is a constitutional matter, and the evidence that Atiku got from Chicago State University will prove it. So based on this, he pleaded with the court to grant their request and admit the new evidence, and he ended by urging the justices to look at Tinubu's records as released by Chicago State University and deliver justice without technicality. Tinubu's lead counsel, Wole Olanibeku SAN, is already upon his feet to address the court. He begins, "My lords, Atiku's fresh evidence has no merit, that it is an unusual application. He asked the court to dismiss the application, that the court should uphold and interpret the law the way it's supposed to be. He also said that the CSU representative should have come to Nigeria to testify before a court, and that INEC should have been represented during the deposition in the United States. He also pointed out contradictions in Atiku's prayers in his petition. On one hand, he asked the court to disqualify Tinubu. On the other, he asked the court to call a rerun election between him and Tinubu. He also said that the law stipulates 180 days for election disputes from start to finish, that this time period cannot be shifted. Therefore, Atiku cannot tender new evidence at the Supreme Court." Comment: It's important to know that Atiku's counsel in their filing cited a Supreme Court precedence where they admitted new evidence from this same lawyer, Olanibeku, to argue and convince the justices to admit Atiku's new evidence, and going by Olanibeku's advice to the court that they should follow the law to the letter. Is he not in agreement with Atiku's counsel? Since certificate forgery is a constitutional matter, the law should be followed. All evidence must be examined. On the contradictory prayers of Atiku Abubakar in his petition, this was why Peter Obi and Labour Party's legal team went hard on proving substantial non-compliance of the law by INEC because it affected them. INEC hid their votes and in some cases transferred their votes to APC as witnessed in Rivers State and other states. Logically, if someone is saying that the election was flawed, the court might have no strong footing to award a flawed election win to another person. If it is truly flawed, it should be flawed for every candidate. Though there's an exception in this case, the election was flawed because INEC didn't correctly record the votes, and Labour Party became a victim as a result. It's a bit complicated and it's obvious they don't want to go down that line. Anyway, let's hear what APC's counsel, Akin Olujimi SAN, said. He asked the court to dismiss Atiku's application because it lacks merit, that Atiku cannot smuggle documents into the Supreme Court without first tendering it at the Presidential Election Petition Tribunal. Now, let's hear Justice Emmanuel Agam's response to Atiku's counsel. He asked him that according to his filing, if the testimony of Chicago State University representative was conducted in a court, that it was conducted in the chambers of Atiku's counsel in the United States. He also remarked that Chicago State University did not issue any letter discrediting Tinubu's certificate, that the matter is serious and borders on national unity of Nigeria. Atiku's counsel is up to respond. He told the court that there's a difference in proceedings in the United States and the United Kingdom, that the way the oral deposition was conducted is the way it is done in the United States. And besides, Tinubu's counsel was present during the oral deposition, and he never raised the issue in court that he opposed the location of the deposition. He went on to correct Justice Emmanuel Agam's position, saying that oral depositions are more effective than letters because they are done under oath. Chicago State University registrar denied issuing Tinubu a certificate under oath. Comment: this is common sense. When you tell someone to write something, he can lie about anything. But it's a different ball game when you tell the person to say it under oath. The person knows there's punishment for perjury. The oral deposition is very effective. That was how we knew that the Chicago State University records Tinubu's counsel submitted as evidence at the Presidential Election Petition Tribunal did not come from the university. The registrar denied it during the oral deposition, that they never received any request to certify documents for Tinubu. It looked fishy from the word go. He made the application and received all records same day. So oral depositions are very effective for people who want to get to the truth, not people who are looking for technicality. Now, let's hear what the chairman of the panel has to say. He started by asking Atiku's counsel what the court should do with the fresh evidence and whether he wants the court to follow the electoral law or the constitution, and that criminal matters have to be proved beyond reasonable doubt, that there are two conflicting letters written by Chicago State University. The first one authenticated it, and the second one discredited his certificate. He asked him to tell the court which one they should rely on. Atiku's counsel responded that the letter he's referring to is the one they issued in Nahoreba, the lawyer they gave Tinubu's records under subpoena last year. Comment: there's no letter ever written by Chicago State University that authenticated Tinubu's certificate. Maybe there's a mix-up somewhere, unless the justice is referring to the letter where they said that Bola A. Tinubu graduated from their university. That's quite different from the issue at hand, which is certificate forgery. The oral deposition is very clear. If they really want to admit the evidence and take a look, they said they've never issued him any certificate, even in 1979 when he purportedly graduated. Purported in the sense that the academic records CSU released to Atiku proves he couldn't have graduated in 1979 because of the short time between the last appraisal the school gave him to the graduation date. In that appraisal, they mentioned exams he was yet to pass, and we all know that if you don't pass all your exams, you can't graduate. No one graduates with a carryover. Where is INEC in all this? Yes, they are in court. Their counsel, Abubakar Mahmood, SAN, also followed the duo of APC and Tinubu counsels in asking the court to dismiss Atiku's application, seeking to tender Tinubu's academic records from Chicago State University. After all the arguments, the court reserved ruling on Atiku Abubakar's application, saying that they will communicate the date to all parties. Next, the court heard the appeal by Allied People's Movement, where they are seeking the court to disqualify Tinubu because of invalid nomination. Tinubu failed to nominate a vice presidential candidate after his placeholder resigned. The law says a replacement candidate must be appointed within 14 days. The justices had strong words for their counsel that they've decided this matter in the past, therefore they shouldn't have brought the appeal to the Supreme Court. The APM quickly withdrew the appeal. Whatever the Supreme Court decided in the past, let's even assume that the court regards this as a pre-election matter, which means that only people that contested the primaries with Tinubu can bring this matter to court, and they have a few days. Is that 14 days after the primaries? So if they don't bring the case, does it mean the law was not violated? No, it doesn't mean that it wasn't violated. There's a reason the law was made in the first place, to curtail the impunity of politicians. If not, a candidate can name his running mate 24 hours to the election. Who will challenge that? Or are they saying it should go unchallenged? The drafters of the law didn't add this in the electoral law and the constitution for fun. It was intentional. The court has a duty to uphold the law, and whatever they come up with doesn't mean that the crime wasn't committed in the first place. Yes, the fact that someone wasn't tried for a crime doesn't mean he didn't commit the crime. Whatever he stole still remains stolen. Justice will one day catch up with the person. On P2B and Labour Party's appeal, their lead counsel, Levi Uzuku Eseyen, urged the court to set aside the judgment of the Presidential Election Petition Tribunal and uphold their arguments and appeal. The court also reserved judgment on the matter and promised to communicate the date for the judgment. Like we said in the other video, they might deliver judgment as soon as they want without the written judgment. They will just give a date to release it. It's not the first time they've done that. They've done it many times. So we'll be waiting to know how they will decide. Though by the questions of the justices, one can already predict how they will decide. Thanks for watching.